name is Javier Ruiz. I'm the policy director of the Open Rights Group, and which is a digital rights organization in the UK. In a previous life, I was a trade union organizer for Unite in the UK, so I have some interest in workplace privacy and data protection. And we have a good range of speakers today to cover the topic. So I'm just going to introduce you to the panel very quickly. So I'll just go in order, so here, sorry, where we are. Yeah, Inge Vanderreken, who is sitting next to me, she's an employment partner of the, this one is not, you can't hear at the back. Yeah, I mean, it's working on this speaker, but not at the, can you hear at the back? Yes, okay. So Inge Vanderreken is an employment partner of the international law firm Allen & Overy, but she's based in Brussels. She advises on the full range of employment and incentive matters with a focus on data protection and privacy. And she has contributed to several publications and lectured extensively on data protection. So she's going to be moderating and bringing up the questions. Then Willem Debeuckelaere, he works for the Belgian DPA, and he's a law graduate from Ghent. He's worked as a lawyer since 1977, and he was the president of the Human Rights League from 82 to 89. He's published on various matters, from legal aid to constitutional law and privacy, of course. And he was nominated a judge of the tribunal of the first instance, and then of the Court of Appeal of Ghent. But importantly, he was vice president of the Belgian Commission for the Protection of Privacy until 2007, and he's been the president of the Commission since. And Willem will be covering our general overview of the legal landscape. Next, we have Alessandro Mantelero. Alessandro is a professor of private law and innovation and international transactions at the Polytechnic University of Turin. He's a director of privacy at the Nexa Center for Internet and Society, a part-time expert in the Nanjing University in China, and program coordinator for various degrees. And he's been at Harvard, Oxford, Nanjing, and also at the Open University of Catalonia. And Alessandro is going to focus on an interesting area, which is the Industry 5.0 and the impact of robotics and data protection. Next to him, we have Shin van der Sype, and she's an associate at Time.lex and specializes in the domain of workplace privacy and data protection, company security, and ICT contracts. And she also teaches a course in electronic contracts, part of a master's course in ICT in Leuven. And in April, she presented her PhD thesis towards an integrated privacy protection in the workplace. So obviously, she's got quite an interest and specialization in the topic. And last but not least, at the end, Marta Otto. She's an assistant professor at the Faculty of Law at the University of Lodz in Poland. She's got a PhD from the European University Institute in Florence. And she's been also a scholar on the International Society for Labor Law and Social Security, and various other organizations in Canada and Europe. She's a co-founder of the Polish Labor Law and Social Security Research Network. And he is obviously very interested. Her main field of research is also on privacy and data protection in employment. So we have a panel of specialists on this topic right now. And she's going to be looking at the profiling of people at work and human rights protection in the age of big data. So, yeah, okay, so now I'm going to load the presentation. So first, Shin is going to, she's going to give us a general introduction to a topic. So I'm going to load her slides. Yeah.
Does it work? But the slides are...
Yeah, I'm going to load the slides. Yeah. And the remote.
Okay, so thank you, Javier.
Yeah.
Yes.
Yeah, no, we need to change. Yeah. The slides. Yes, no. Hopefully. Okay, this is in Dutch. So, we have a Dutch speaker, knows which is the. I don't use PowerPoint, so I cannot use muscle memory on this thing. To put it on the. We want to load.
You don't have. Oh, you have to take here, I think.
Huh?
No, but the other just.
But you had one slide, like.
Yeah.
But you can
Well, I can
start.
I can start
You can
already
start.
because I only have one slide, so it's basically my name and the title of the talk. I will keep it short because we are already running out of time. But my role in this panel now is to stress out some key elements regarding the GDPR at work. So in the employment context, we all know that the GDPR strengthens the rights of data subjects, that it adds new obligations to controllers and processors. And we know about the administrative fines, that was the previous panel. And we also know about Article 88, which allows member states to adopt specific legislation for data processing in the work environment. Now, there are some basics that employers will have to consider every time that they process the personal data of their employees. For most of you, this will be, repetition, but it's important to highlight these key principles. So first of all, employees are almost never in a position to give, refuse, or revoke consent. And this is because of the power imbalance that exists between employers and employees, because of course there is a subordinate relationship because it's key for the employment relationship, and this pressures the free consent. Luckily, there are several other legal grounds that you can base the processing on, and this is typically performance of a contract, legal obligations of the employer, or the legitimate interest of the employer or of a third party. A second point to consider is transparency. This is already the case. Transparency is already very important, but somehow this is often forgotten. There are so many examples of clauses in employment contracts referring to data protection clauses in the work rules, but then when you actually check them, they're not there, or the other way around, and this is very confusing. Now, of course, employers also need to be aware of proportionality and data minimization, and a very easy one is to delete the resumes, the CVs of candidates from the moment that it's visible that they won't be eligible for the job. Then the question whether a DPO is necessary or not. Well, typically I would say no for when you're just processing data of your employees. Well, in Germany there is of course the exception, then it's almost always yes. But otherwise, I don't think that that processing personal data of employees is large scale processing per se, or also not like special categories. So then the data protection impact assessment, there we have to say yes, because there was this opinion from the Article 29 Working Party explicitly saying that if you systematically monitor a vulnerable group of people, then you need to conduct this DPIA, so this impact assessment. And systematic monitoring is also CCTV, for example. So that's a yes. And then a final, not to forget here, is data transfers. So in practice, when I talk to companies, I often have the feeling that they think that this is something that only happens to big companies. But of course, this is also key for small companies for every time that you are going to transfer personal data outside of the EU. Now, a more interesting question actually is, will this all help employees? Will the GDPR help employees? I know that GDPR, it's very promising because it gives so much more ways of enforcement and makes rights more explicit, but will it help in the employment environment? Then why do I doubt that? Is because of the subordinate relationship, because there is this huge power imbalance. The reasoning behind this, well, the thing is I really like to talk about the tragedy of overprotection. I think that overprotection is never a good thing, and I am afraid that in this employment situation, the GDPR is overprotecting employees without actually giving them something to enforce it. Because when you are an employee, you can't give consent. This is something everybody is always saying, it's true. But then imagine the person going to court during an employment relationship. So when you have to go back the next day to your job, you're not going to go to court, you're not going to go to Data Protection Authority. Probably you're not even going to your DPO in the company if you have one. So it's a fact that there is a very strong protection on paper, but then the problem with this strong protection is also that it's very difficult for companies to comply with all the rules. And then given that employees during their employment contract, during their employment relationship with a company, they will not take any actions, well then everything might explode after the contract ends. So because of the huge threshold to go to court, to go to the DPA, there won't be much discussions during, that's clear. And then after, either it's not relevant, so when you work for a company and you know that they breached a lot of your data subjects, right? Well, after the contract ends, after you're not working there anymore, it's not really relevant. It's not, you're not going to take some revenge actions, usually. And sometimes it is relevant, but for a completely different reason. And think about an employee A. Employee A gets fired, dismissed, for just cause by company X. And then X had been snooping around on the devices of the employee, and it's clearly, it's a breach, but okay, it's still, he uses the evidence to prove the just cause of the dismissal. Well, what happens then? Employee A will go to court and to fight the dismissal, and then, but you can see, judges will then have to rule also on the topic of privacy and data protection, but it will always be in the context of a dismissal case or in the context of another employment dispute. And in this way, the question is not whether someone's data subject rights were breached and maybe how to fix it and so on and so on. No, the question will more be, is the breach acceptable? Is it justifiable given the context of the employment issue? And this problem of the difference in time and context, the moment, on the one hand, the moment that the breach occurs, and then on the other hand, that it gets a legal meaning, that is something that is not covered by GDPR, of course. And I don't say that the GDPR should have done that, but it's a vacuum, and I think that a lot of employees will fall outside of protection because of this. Thank you.
So, Marta, you want to go and hopefully load your...
Today I would like to turn your attention to a very specific problem within the data processing in employment, namely profiling of the employed. It doesn't work, sorry?
No, I think you
now it works?
speak closer to the mic.
Really close, okay. Now it works? Yeah. Okay. So as I was trying to say, I would like to turn your attention to a very specific issue, namely profiling of the employed and the potential human rights implications of such processing. Doesn't work. Whether you like it or not, radical transparency in the algorithmic decision making is coming at you fast and is going to change your life. That's how Ray Dalio, an American billionaire, started his TED Talk in April 2017. And this belief in the idea of the so-called meritocracy led him to introduce in his company, currently employing almost 1,500 employees, an artificial intelligence management coach that is scheduled to vastly improve the capability and the integration level within the company. And so far, it's not an isolated case. Corporate giants, including Google are embracing the power of the so-called people analytics to vastly improve the promotion decisions, the hiring decisions, as well as termination decisions in the employments. Analytics are superior because unlike the human resource standard techniques, they say a lot about the future. On the basis of seemingly neutral facts or habits. For instance, as the research of Nathan Newman shows, the pre-hire personality testing taken to the next level by algorithms helps employers screen out employees who will insist on higher wages, who will try to organize, and who would support the unionization. So on the one hand, I don't know where to, okay. On the one hand, it could be profiling as such, or people analytics based on predictive algorithms, of course, could be a valuable tool that enhances the efficiency and security of business operation by optimizing the workforce productivity, by creating greater consistency and fairness in the decision making, and the overall ability to detect the fraudulent behavior. On the other hand, it is rather self-evident from the labor law perspective that it exacerbates considerably the informational asymmetry as such, and as a result, the overall inequality of bargaining powers that is inherent in the employment relationships. As such, it poses really considerable threats to the human rights protection of workers, in particular the right to privacy and the right to data protection, but also the principle of equality, the principle of non-discrimination, as well as workers' social rights, the right to work, the right to protection against unjustified dismissal, the right to fair and just working conditions. So one of the key questions that we need to ask nowadays is to what extent the so-called people analytics could form a stable element of the institutional culture of modern workplaces under the European multi-level system of privacy and data protection that I tried to portray in a very oversimplistic manner here. That has recently been remodeled considerably with the interaction of the GDPR. So let's look, I would like to look with you at the very basic just to see how far it will go with regard to employment context. Starting from the definition. The definition as such is composed upon the three elements. Profiling as such constitutes any form of automated processing of personal data, but unlike Article 22, which is based on solely automated data processing, the profiling definition uses any form of automated processing, which means that if you have a bit of human involvement, this will also mean a profiling activity as such. It has to consist of the use of personal data. As you know, the personal data concept under the GDPR is conceived pretty broadly, and it encompasses not only the information relating to private life, sensu stricto, but also working conditions. Also, what is important to note is it covers both objective informations as well as subjective information such as assessment or opinions, which forms really crucial category in the employment context. And then the definition clearly stipulates that the aim of this processing has to be to evaluate certain personal aspects, in particular to analyze or predict. This means that even though, for example, we can have a processing activity which will not involve the prediction as such, and it will just classify the employee, or it will include just a basic assessment, it should fall within the definition of profiling under the GDPR. So under what circumstances is going to be permissible? The activity of profiling as such is not prohibited under the GDPR. However, as a form of data processing, it will be subject to the general rules governing the processing, and first and foremost the legal grounds, and afterwards the data protection principle. The recital 71 further specifies what to do, what the employer could do to ensure fair and transparent processing. It enumerates such issues as using appropriate mathematical or statistical procedures, implementing technical and organizational measures, and securing personal data from the potential risks involved for the interests and rights for data subjects, in particular the discriminatory effects. So while individuals, they do not have a universal right to object to profiling, they may object in certain circumstances, depending on the purpose and the legal basis of the profiling. So some of them, they are enumerated here, and the most troubling for us, as Shin already mentioned, is the legitimate interests as such of the employer. Because of, as you know, the array of legitimate interests is pretty wide in employment context, starting from ensuring business efficiency, protection of the rights of the others, including the employee itself. So in this instances, the controller shall no longer process the personal data unless he can demonstrate the compelling legitimate grounds for the processing. This would mean, if you look at the relevant guidelines coming from the working party, that there always must be a certain balancing exercise between the competing interests of on the one hand of the employer, on the other hand of the employee, and the basis for his objection, which in principle may be personal, social, or professional reason. The point is that looking at the, if you are familiar, and I'm pretty sure you are since you are here, with the relevant case law coming from the European Court of Human Rights, it is not that sure how this balancing will proceed, and the main reason for that is that the court does not develop a kind of consistent line in when it comes to balancing the rights of the employers and rights of workers. The most troublesome for me is the proportionality principle and the fact that not always it is used in its full terms. Namely, very often it happens that that the court only takes a look at the suitability and the least intrusive / necessity criterion, not looking into the clue of the proportionality principle, namely the balancing of the harm. So what is the gain and what is the risk on the other side? And this gives us very different results, and it's difficult to predict how this balancing could work. 1 minute, one. Of course, as you mentioned, as Shin mentioned, the GDPR, of course, strengthens the rights in a considerable manner, especially the information requirements. On the other hand, we have a whole array of data subjects' rights, right of access, right to rectification, right to erasure, right to restriction of processing. The profiling is very much likely to involve data protection impact assessment. Some of the risks can be mitigated by introduction of the data protection officer as such. Then the most important thing is that there is a right not to be subject to a decision based solely on profiling which produces legal or similarly significant effects concerning employees. As such, this is a right, but in practice it works as a prohibition on profiling that is completely automated and that produces legal or similarly significant effects. The question mark, like what does it mean in the employment context, the legal effects or similarly legal effects, hopefully we'll have time to discuss about it. Then there's another layer of measures to introduce the so-called suitable measures to safeguard data subjects' rights and to obtain first and foremost human intervention, express their opinion, their point of view, obtain an explanation of a decision reached, challenge the decision. Again, how to introduce it effectively in the employment context. And then the last thing, Article 88. As you know, the member states, they have been left with a margin of maneuver to specify, to concretize the protection in the employment context. The point is that the game is over, okay? The point is that, but I would like to discuss it with you maybe afterwards, that from what I've heard, for example, yesterday, only 2 states till now, namely Germany and Austria, correct me if I'm wrong, decided to implement specific measures, decided to concretize the norms. Okay, I think I will leave it here, and hopefully we'll come back to the issue of the possible concretization of norms afterwards. Thank you very much.
Thank you. Sorry to have to rush. We started a bit late with the changeover from the previous room. We were squatting our space a bit, and so we have to rush if we want to give time for you to be able to ask some questions. So our next speaker is going to be Willem. Yes, and I will load his presentation. Work? Oh, so does anyone? Sorry. Yeah. What is that? Sorry. What does that say?
Beveiligingswaarschuwing. It's an alert.
It's an alert.
And you're okay.
You have 30 seconds
So
to
it's
leave the
working,
room.
yeah. Well, it's kind of working
This
here.
vessel
So
will be destroyed in...
Second option. There are 2 options and we need to take the other one.
yeah, I'm just trying to figure out how to
But
go
we
there.
don't get these options.
Here?
Yeah, and then okay. And then okay. Yeah.
Phew. Okay, that's 1 minute we've lost there. So let's
Thank
try
you.
to stick to our 10 minutes. Yeah.
Thank you very much. I will try to be very quickly, but I have to start with a confession. When I was in 2005 appointed as Vice President of the Belgian Data Protection Authority, at the moment I had to sign a letter that was prepared by Jan van Zevenand, who is in the back here of this room. And I said to Jan, why are you don't mention this legislation and this collective agreement, because that is the real stuff on the problems of processing personal data in a working environment. And Jan said to me at that moment, yes, I know it very well, but the Data Protection Authority before you had decided that this collective agreement is illegal, is not in line with data protection. So I was a little bit wondered why it was so. We got some discussions about that, and he said also to me, I have to confess another thing, he said. You must know that Professor Blancpain, who was one of the biggest law specialists in this field of labor law, has said that the position of the Belgian Data Protection Authority was a position of the Ayatollahs, the Ayatollahs of the data protection. So with this problem before us, we started to regard the interaction of the reality, the jurisprudence, but because there was a lot of jurisprudence where discussions about privacy and certainly data protection were involved, because in a lot of cases, and we have counted then in 2007 more than 500 cases only from Belgium tribunals and courts, were handling on that point, mostly according to the proof. What is this proof legal? Can it be used against the employer or against the worker? So we were at that point coming to a complete other viewpoint, and that have been led to a lot of, let us say, new insights. We have made also a whole discussion with the trade unions, also with the representatives of the employers, and we have had, let's say, 3 big reports on it. We have one on cameras. There was also a collective agreement according to that. We have had also one on the surveillance, the online surveillance, who is CAO collective agreement 81, who is very important in the Belgian reality. And then we have, that's recently more and more important, geolocalization. That are really 3 topics where we are receiving a lot of questions, a lot of discussions, and also we have had also to handle 3 complaints, former complaints, every time introduced by trade unions against an employer. 2 of them have led to an agreement, because we as Data Protection Authority, we don't have the power really to resolve or to give a sort of a judgment, or we have to try to find a solution, and in 2 of these 3 cases we came to a solution between the representatives of the workers and the employer. We have had also a lot of legislation on that point. We try to make every 2-3 years, and now it's a very difficult one, to make a whole compilation of legislation. We are now working at the 4th edition, and you see here 1/3 of the legislation that is in according to labor law, social law. So you see that there is a lot of few acts. You have also cooperation agreements, you have royal decrees, and at the end, the 3rd page, you will find 5, 6, 7 collective agreements who are handling on this topic. Of course, for us, the most important leading cases are the star decisions, so to say. You have Copland versus Great Britain from the European Court of Human Rights, and recently you have this case of Barbalesca versus Romania, who is repealing, who is rephrasing the principles of this case, and we were very happy, and it was also the work of Jan, to look if this case law is in accordance of the Belgian legislation, and of course our opinions and the information that we are giving via our website. Recently, on the European level also, we have an opinion of the Working Party 29, who was recently adopted, June 2017. It's really a wonder that we came to this opinion, because everybody is working on the GDPR, and there was practically no room or activity or energy to work on that field, but it was also the result of, I think, 2-3 years of intensive work and discussions on the European level. And I'm happy that also this working paper is now available for everybody who is looking for insights and information on this topic. The GDPR, I mentioned it already, Article 88 of Chapter 9. Chapter 9, as you know, that's the trash of the GDPR. Everything where nobody was really in concordance. As I said, okay, we laid it on the member states. That's of course very easy if you want to make an instrument for everybody, but you have a lot of topics where you are not agree, then you said, well, we give it to the member state. And that's the case for labor law. And I think it was something that was to foreseen, because I think that labor law is much more related to the habits, to the specific culture of a lot of countries. So it's not so easy, I think, to find a common ground. That's also the reason why the Working Party 29 take 2-3 years to come to this working paper that I just have shown. Article 88 is saying in a first recital that it is very important in the law to give guidance on all these principles. And I'm particularly very happy that they mentioned not only law, but also on the second place, collective agreements. And I think that in these situations, we should be humble, and we should be also realistic. And in my experience, it is only possible by the way of law or collective agreements to redress a good data protection reality. It's a reality that trade unions and employers can reach to these agreements, and it's much more balanced than the situation where you have one individual against the employer. And Yang Xing already mentioned it, this difficulty of balancing, so I think that that is very important. So we are running to this Article 88, you can read it, you can learn it by heart, but you have to do it certainly with Article 24 of the GDPR. That you have to know really by heart, because there you find one of the most important elements of the GDPR, and that is accountability, also Article 5 of course, and the risk analysis. And I think that these are two elements that should be kept very closely in mind, on not only for workers, not only for trade unions, not only for employers, but also for data protection authorities and judges when they have to handle with cases on the labor situation. So thank you. I will leave it to that for this moment. And of course, we have the possibility to answer your questions. Thank you.
Thanks, Willem. Now, people here. This one works. Okay, so we go. Yeah. Yeah. So the mouse. No, the mouse is in the thing. Where is that? You can do it with the. Let's see if we can get the. What is the mouse? It's like we lost the mouse when we. Here it is. Phew. The mouse.
This one.
This one. No. Mantelero. There you are.
Yeah.
Phew.
Thank you. My presentation is a bit different because the previous presentation mainly focused on control of employees. And this presentation is the result of a project that I carry out with my university and different partners in robot area, FCA Automobile and Comar Robotics. And in this project, we focus on Industry 5.0 environment. Industry 5.0 is a context in which the robots interact with the humans, and this creates a lot of flows of data and flows of information, because these robots are not simply robots that stay on the desk, but are robots that interact by sensor that are on the body of the humans, and in other cases are robots that are added to the body of the humans. This creates problems not only in terms of control, social control, but also in terms of by design approach. So our work was to focus on how to implement the principle of privacy by design in this specific context of Industry 5.0. And the by design approach is mentioned as a principle in GDPR and is a sort of application of general principles that are mentioned in Article 5 of the GDPR, mainly proportionality and minimization. We should remember that these principles are also in the recommendation of the Council of Europe on protection of data subject in workplaces, adopted in 2015. And the first case that we analyzed was that kind of devices that is robot that is put on the shoulder or on other parts of the body in order to add more force or to complement the stress of the body of the worker. The first approach of some companies was to use a body scan to scan the entire body of the person in order to create what we call the Type B model, in order to create an exoskeleton that fit perfectly with the body. We suggest adopting a by-design approach and to consider also a Type A model. The Type A is based on a model that is adaptable by mechanical devices and require the measurement of the body, but not a specific scan of the body. So in terms of research question, the research question was if we are able to achieve the same result in order to have an exoskeleton without an invasive approach like making a body scan and collecting biometric information. So in this sense, we imagine that there are some cases, there are many cases probably, in which we need an exoskeleton that doesn't necessarily fit perfectly with the body and can be adjusted by some devices on it. In this case, we have only to collect the information about some measurement of the part of the body. And this measurement can be collected in a quite anonymous manner if you want, because you can select the person and measure the body and then fix the range and build the robots on the basis of this range. In some cases, you have to be careful not to use high-resolution measurement, because if you have a high-resolution measurement, you have again a personal information, because if you use a very high measurement for part of the body, there is only one person with that specific characteristics. There are some restrictions in terms of sex, because if you have few, for instance, women in the group, you can partially identify the person. And so in some cases, probably we cannot use anonymous data, but pseudo-anonymous data for the first stage, in which we have a list of the person and a list of the measure. But then we delete the first list, and we can aggregate and have anonymous data. This permits us to create a Type A model that is not invasive. But there are some cases in which we need a high level of adherence with the body, or to compensate some limits of the body. People with disease, people with some specific physical limitation, and so on. In that case, we need an ad hoc specific devices that will be perfect fitted with the user. In this case, we can use body scan, but again, using proportionality principle, body scan on the selected part that is necessary to scan in order to create the device. Obviously, this is a case of biometric information that are collected. We need a data protection impact assessment. And this poses problem in terms of data retention. In terms of data retention, there are two different scenarios. The first basic default scenario may be you collect the body scan, or the part of the body scan. You create the exoskeleton, the wearable robots, and then you delete the biometric information. And this is the default rule. But there are some cases in which the wearable robots is built in order to compensate some disease of the person, and this disease may have an evolution, and the exoskeleton should be modified. In order to have a second stage of a new body scan and collect new data, it's better to maintain this information. And probably we can maintain this information in that case till the end of the labor relationship. In this case, we cannot anonymize this information because I have biometric information, so we cannot anonymize. In terms of storage, we use a centralized model to store this information. Although the Italian data protection authority suggests for biometric information to have a decentralized model, but in this case it's justified in terms of security, because the higher level of security, and in terms of the fact that we need, in some cases, as mentioned, to modify this model. And so we cannot put this model in device given to the worker, to the user, because this is an high risk in this term, in terms of efficiency. The second scenario is represented by self-adapting workstation. These workstations are based on a sort of sensor that are able to detect the condition of the workers in the physical parameters, and are able to optimize the condition of work. Obviously, again, it's not possible to have anonymization because we know the people that work in a specific workstation, and we can use pseudo-anonymization. There may be some exception in the case, for instance, of workers with a specific health disease, health condition, that should be monitored during the activity in order to don't increase the stress of the worker, or also in a specific condition, high-risk environment. And so in that case, we need personal data. And again, there is a problem in terms of data retention. The default rule is the work shift, but there are exceptions, because in some cases you need to monitor the health condition for a longer time, or in some cases you need to know the condition of a specific person in terms of safety, because the environment is a high dangerous environment. Another device is this kind of sensor that are put on the body in order to interact with the robots. In this sense, in some cases, we have anonymous information because the robots don't need to know the person. For instance, if the robot turns around, it needs also to know that there is a person, not who is the person. But there are exceptions in terms of high-risk condition of work. Again, the exceptions are similar to the previous one. What is interesting, and I want to conclude, is the fact that this kind of device creates a new kind of environment. And the environment is based on a safety and a sort of customization of safety. So right now, we use safety measures that are standardized and are always the same. In this case, using personal data in some cases using also invasive forms like biometric data and so on, we are able to personalize safety. So there is a sort of trade-off between data protection and safety, and that may be taken into account also in terms of legal ground, because there is a specific exception for the compliance to a specific law requirement, and we have law requirements in terms of safety. So the future may be a reflection on the personalized safety and how we address this kind of challenge. This is the group that work on this topic, and there's a group in my university at Polytechnic. Thanks.
Okay. Thank you all for your excellent contributions. I think all these presentations show the very difficult and delicate balance between, do you hear me? Is that, okay. So I think all these presentations show the difficult and delicate balance between, in the working environment, between on the one hand the employer's prerogatives, and on the other hand the employee's privacy entitlements, and also on the employment rules versus data protection rules. And the GDPR realized itself that it may not have given all the answers. So it gave the possibility, as already discussed several times here, gave the possibility to the legislations, to the jurisdictions, to provide for more specific legislation with respect to employment. And my question to this panel is, one, do you think it's useful, indeed, that these different jurisdictions will provide for more specific legislation with respect to data protection and employment? And secondly, if you think it's useful, do you have some guidelines to give to these jurisdictions?
Since I mentioned legislation a couple of times, we should know, I think you know probably, that okay, that the issue of the employment-specific instrument at the EU level was already raised in 2001, 2002, when the European Commission entered into dialogue with social partners. For, I would say, obviously reasons, in a sense, a very difficult compromise that has to be reached in this area. We didn't end up with having an employment-specific directive. Now we have Article 88, which changed throughout the negotiations between different institutions. Okay, there is a possibility to introduce employment-specific legislation at the national level. That's hopefully that will happen, because as you can see, there are really enormous issues concerned with translating, for example, the legal grants criteria, such as consent, for example, how much it should be used within the employment context, what should be its legal force as such. Should it work as a procedural bulwark, or should it not, and in this case, it should not preclude the courts to assess other fair information principles? What is the legitimate interests of the employer, how it should be translated? Yes, keeping up to the point. So to me, I would, but of course, it won't make, if we have like national employment legislations, it won't make our life easier, because you will have to read the GDPR in connection with the national legislation. So it will impede, in my opinion, even though the GDPR is framed in a very strong manner, it will impede the free flow of information within the employment context in Europe as such. So in the future, I would prefer maybe a complementing employment-specific directive coming at a certain point.
Okay, thank you.
No, I agree.
I should comment. I'm in the National Committee, the Legislative Committee in Italy for the new data protection law. And the main approach is we have not to touch nothing. The GDPR is okay, and we don't add nothing. If you look at the other legislation adopted in other countries, there are not a lot of provision in order to apply or give voice to this Article 88. So I'm a bit skeptical in terms of specific provision right now. In the future, probably will be different, I don't know. But my personal experience at the moment is that there is not a lot of interest of the national parliament or legislative bodies to take a specific position on this. Thanks.
Well, a few months ago, I was invited by the National Committee of Employers and Trade Unions, and the first question was not to say what is in the GDPR, but shall we need to refrain to regard again all these collective agreements that we have to do? And the answer was, of course, yes. And one of the members there said, yeah, maybe we should do that on not on a national level, but on a European level. And why should we do that? Well, most employers are the more and more acting in several countries or acting on the whole European field. There was also at a certain moment the idea maybe we should make a binding corporate rule not for one group of companies but for really sector groups of companies. The trade unions were a little bit surprised because what is a binding corporate rule? That's something from the multinationals and so. But I think that there will be much more interference also by the general data protection regulation, but also by the evolution of companies and industry, and that we will slowly merge to, let us say, a sort of European labor law and data protection that will come together. That's, I think, one of the lessons learned that I had a few months ago.
Okay, thank you. One last question from my side, but I think there will be plenty of other questions from you also. Another specific element with respect to employment law and data protection is a specific role of consent in an employment relationship. And the GDPR has changed the conditions for this consent, and we also saw that in the advice of the Article 29 Working Party. So my question to the panel is, what do you think the role of consent as legal ground in an employment relationship can still be? And possibly if there is no role anymore, do you see other legal grounds that employers should apply when they want to process data?
I think I've mentioned it already. I'm not a great fan of consent in a working environment for obvious reason, information asymmetries, the power asymmetries, etc. I could imagine that, as I mentioned, it could work as a procedural bulwark as such, which should not preclude the courts to assess under fair information principle, and especially the proportionality, and preferably the three-pronged proportionality that would also involve the balance of harm between the competing sites. On the other hand, I didn't mention this, for example, when it comes to profiling, you have even higher requirement of explicit consent, which should be translated according to Working Party as a written statement, but still, does it really change much in what form it's going to be given in the employment context? No, and especially we should be really careful about the consent, also looking at the judgments of the European Court of Human Rights, which also are not that consistent with regard to how they interpret the role of the consent in the working environment, especially the whole construction of the protection under the European Convention of Human Rights, which will be important reference point also under the GDPR, is the so-called reasonable expectations at workplace. And reasonable expectations at workplace, given the huge role, if we assume that the consent would have a huge role, then in practice, according to the established line of judicial decisions, well, this would mean no expectations of privacy or data protection in the employment. That's my opinion.
I would like to add some small things. So to come back to your question, the role of consent, I think it should be limited to, well, something that, not a legal ground, basically. I think that employers really should focus on the other legal grounds. I think that performance of the contract and legitimate interest, and legal obligations, of course, are the most important ones. So consent, I think it can be very useful, definitely, to prove that you were transparent, that you informed the person, but consent as a legal ground, I think we should stay away from there.
As I mentioned in my presentation, in the case that we have studied, probably there are other legal grounds like a specific legal obligation in terms of protection and safety. But moving from the specific case to a broader idea about consent, I'm personally, as academic, I'm against this idea of individual consent because it doesn't work in this context. Unfortunately, the GDPR maintained this individualistic idea about consent. Unfortunately, in this case, in the working context and many other contexts, the information are collected on a massive scale, and the idea is to monitor entire groups. And so the idea is to focus and to conduct further investigation on the collective dimension of data protection, and also to use the collective consent that already exists in the working context, in which historically there is not an individual consent, but it's the consent expressed by the representative of the workers. So it's this typical case in which you can continue in this sense to also have a better outcome in terms of regulation, not so focused on individuals that in many cases are not able to understand and to express a consent.
The only thing that I'm completely agree. I'm also not a great fan of individual consent in these cases. Collective consent is something else, and I think also that in the cases where, for example, you have to make a regulation on the way that you can control as an employer your employees. There you have still some fields where it is only the employer who can decide. Well, on that moment, I think that also there is a role for data protection authorities and for the tribunals to interfere, because I think that ticking the box, and that's the only thing that you can do as an individual employer, is not the real way to handle that.
Thank you. Are there any questions?
Everyone's so hungry that they want to-
Or is everybody?
Oh, yeah. If you can speak up, and then we will repeat. We will repeat the question on the microphone so everyone will hear.
I was wondering what the role of unions is in all of this. It was mentioned briefly before, but I'm working with Ruiz and Moderator, one of the main unions, and it's just amazing how lost they are and how little help is targeted at them. And they realize that there's issues that they need to tackle, and they want to be proactive, but it's just a new world. So I was just wondering whether any practices or unions are taking this seriously and asking for help, that may have developed guidelines, or that may be helping governments, other governments work on these kind of regulations.
Good question. So it's about what is the role of the unions in all of this?
The second question also?
The first slide featured the Belgian law on privacy in the workplace. It was French, but it was fast. I didn't have time to read it. But I kind of caught that meant there's a possibility for cameras in the workplace to violate the privacy of an employee. Sorry. So my question is for example, right now in this room, if there's a camera somewhere, is there by any means of legal any interpretation which can lead to that camera violating my personal space? I mean, do I have any sort of personal space while in this room? Legally speaking. I would have one more in the workplace too, which is supposed to be publicly first. Yeah.
Okay. I would propose to you want to repeat for the
Yeah.
recording.
So it's in fact about camera surveillance. How far can that go? And is it possible to keep a personal space where you don't have the cameras on you? Is that an entitlement, privacy entitlement?
I would propose that we try to narrow down the question to actually workplace surveillance, because that could be a very, very broad question.
So we limit it to workplace surveillance on camera, because the cameras can be everywhere, but we're talking about the workplace. Is that fine for you? Okay.
Well, maybe I can give a quick answer in combining the two questions. We have in 2007 here in Belgium a strike of 3 days, lockout of the workers who were not agree anymore with the cameras that were put on the working places, even in the toilets. So on that moment, the union, and on that moment, of course, trade unions are very important to enforce, to empower this reaction. And it led to not only to a strike of 3 days, but also to, I think, 2 collective agreements, because there was at a certain moment a collective agreement, but the employer, who was a young business MBA guy, who was trying to really to maximize this first agreement. So another strike of 2 days then, and then they have really made an agreement between the trade union and the employer, where and on what moment, in what situations, every camera could work. So, for example, when there is free time, when you can give your coffee and your bread, if you have to eat, no cameras. So simple as that. But you see there that it is very important that trade unions can come up for the rights of the workers.
I agree with William, and I try to add something from a different perspective. So we don't necessarily act after the fact, but we can prevent. And the idea of privacy by design and also the provision that say that when you design a new application, you have to involve the stakeholders that there is in the GDPR, and it's presented as an option. But this is the case in which the engagement of the stakeholders can be used to design a better system that prevent the collection of data, that reduce the invasion of privacy. So I think that we can merge these two solutions, the preventive approach, engaging all the stakeholders, it means the workers and their representative, and it doesn't work using an ex post approach that is based on reaction and negotiation and so on. So we had also to maintain the first part.
Well, probably, well, I would say that also that's why we need a legislation, and preferably legislation which would not concentrate on the protection of the very vague category of personal data. What does it mean, the personal data in employment? But rather practices as such, monitoring, profiling, etc. So it shifts a bit the emphasis, and it can help to create certain norms what to follow. Otherwise, you will get to the court, and basically it will much depend again upon the how carefully it will assess the proportionality principle. And let's say, for example, your employer installed the camera just to see in the canteen or in a public space, in brackets, just to see whether you are how do you work, and how productive you are. No, but for example, if it's just monitoring the picture, it could be fine according to the proportionality principle because of the business efficiency, etc. No, but for example, if it also managed to record the voice and hear all the talks during the canteen, also expressing bad opinions about your employers, etc. Can happen. There were cases like this in the United States, from what I know. Well, the question mark, still remains in our heads. What could be the answer? No, the logic says it shouldn't be like this, but then it will much depend upon the court. That's why, again, I do believe that certain norms and certain standards should be placed in the legislation as such, but not covering the personal data as such, but practices, the privacy and the private and the personal data infringing practices as such.
So actually, apart from being a chair, I'm going to add a little bit of my own experience on that. When I worked for a trade union, I had to deal with warehouses where workers wore bracelets, and all their movements were tracked, and they were fed into an algorithm that calculated the productivity. And the lesson for a trade union there was that apart from legal knowledge about data protection, they needed a lot of technical knowledge to be able to understand what was fair calculation of productivity, how to balance. And there was a big problem with 50-year-old British workers versus 18-year-old Eastern European workers that were a lot faster, and the fairness on the pure calculation was that, obviously you have to promote the 18-year-olds, but there were technical knowledge was as important as legal knowledge in many of these cases in employment. And there is a lot of work, and they definitely need a lot of support. Thanks. So I think we are done. Okay, well, so I'll carry on as a chair now. To thank you very much for coming. We won't stand any longer between you and your food. Dangerous. So yeah, thanks again for coming. I guess of course all the panelists will be on their way back to the food. I'm sure they will be happy to take on any questions and follow-ups you have. And I